All right. You guys know the drill. If you're watching this on a replay and you don't want to listen to me ramble for a couple minutes before I get into it, skip ahead and just skip to where you see the document on the screen, and that's where you want to be. But hey, guys, I haven't been doing too much of this this past month. The Justin Baldoni, Blake Lively stuff slowed down a lot, which is expected. While we wait for the judge's ruling on the motion for summary judgment on the pleadings. Not too much action there. And I just decided to take a little break while that was, possible. Because if they do go to trial, I'm going to be very, very busy in the coming months. So I've just been doing my regular day job and not doing YouTube too much. But I wouldn't have actually seen this because this is this kind of declaration that they've made that they're going to do an appeal came in the New York State case. So it's not in the federal case. It's the anti-SLAPP case that the New York Times filed against the Wayfarer parties. They have asked for a stay because they intend to file an appeal to the federal judge's ruling dismissing their lawsuit against Blake Lively, Ryan Reynolds, Leslie Sloan, the New York Times. I don't know if I'm forgetting anyone, but, so right now, the only active case is the Lively versus Wayfarer case and the Jones-Abel case. And the Jones-Abel case doesn't even have a trial date yet. It's a related but separate case related to the publicist matters. And it's been kind of going on concurrently, but at the same time, they don't even have deadlines for filing a summary judgment motion or anything like that in that case. So, yeah, this one was the one that was dismissed last summer. I remember I was in Australia getting ready to fly home. It was a very odd time and literal odd time of the day for me. And I saw this ruling come up and the judge had thrown out or gutted most of Justin Baldoni and the Wayfarer party's claims against Blake Lively and Ryan Reynolds, basically dismissing Ryan Reynolds and the rest of the parties other than Blake, from any sort of legal action, except for Jones. But one second, guys. Sorry about that. Anyways, I remember that was a pretty devastating blow to them. And then people wondered if they would amend because there were a couple of claims, the smaller claims, that the judge had dismissed without prejudice, which means they could have amended those claims and try to see if they could bring those forward. But the major claims that they had brought were all thrown out with prejudice, meaning that they couldn't amend those claims, but they could appeal it. And TMZ incorrectly reported, to everyone's shock, that the Wayfarer parties had run out of time to make their appeal. But actually, the timer doesn't start until the federal judge rules on Blake Lively's fees motions in that case. So the timer hasn't actually started there. And they don't have an appeal on file because the judge hasn't ruled on fees. So here, the New York Times filed an anti-SLAPP suit asking the New York State Court to award them fees based on Wayfarer's lawsuit against them. They basically want Wayfarer to have to pay for that. And the Wayfarer parties are saying, no, we don't want to do that because we're going to appeal the dismissal of the lawsuit against the New York Times. So we'll go over and read that. But if you can't find it on the the PACER docket or the court listener docket, it's because this is in the New York State Court, not the federal court. And I wouldn't have seen this if some people hadn't sent it to me, because usually I'm only looking at the federal dockets. I don't usually use people's names in case they don't want me to, because, lots of people like to stay anonymous online, so I won't do that. But somebody did message me this on Instagram, and somebody did message me this on Twitter, so I thank them for that. It's appreciated. I need to email this to Andy, by the way. Don't let me forget to do that, Michelle. Kim. Michelle, thank you for being a new member. If you haven't yet, and you're a member of this channel, you're already, paying the membership fee or whatever, and you haven't seen it yet, you might want to go to the membership tab. Last week I did kind of an interesting thing for the members only video. It's like this cop who was caught walking around a park on his day off with his wang out. It's kind of an interesting, different type of thing. I was just trying to do something for people who support the channel or whatever. And so the stuff that I do for members only is going to be once or twice a month, and it'll be kind of a different type of thing. But Mayor X5, thank you for the $10. Happy Friday. I appreciate that. And Kim, thank you for the $5. Appreciate that. Pacer Bucks, thank you. Luckily, this one didn't have to come from Pacer, but I did check Pacer. So just to see if there was anything else there. Hey, what's up, Bruce? Don't pretend you know what a wang is. People are like, with his wang out. No, it's exactly what it sounds like. And yes, his wang was out on purpose, but there's a twist. There's a twist to that. It's interesting. But yes, you can go to if you go to my YouTube channel and you go to the membership tab, you'll be able to find that there. So say wang again. Thanks, Bruce, for being a member for 21 months. Thank you. Wang. All right. Anyways, let me pull this up and we'll go through that. It's not a huge, long document, thank God, because I'm just not prepared to dive back into reading huge, long documents. I did see the New York Times did a follow-up article on the Lively Baldoni action, and I don't know. I started reading it, and it just made me want to log off. So that's what I did. I haven't gone over that yet. We're not going to do it this afternoon, but maybe tomorrow. I think tomorrow would be a good time for that. But right now, we're just going to go over this, where they talk about how they're going to appeal. Somebody asked me if this was like standard, and to tell you the truth, I don't know. Maybe it is just a time buyer. I don't know. But they did declare that they intend to appeal, so that's what we got. Okay. Give me 1 second here to drink some water. Okay, so the New York Times asked for a summary judgment in their state court case against the Wayfarer parties because they're trying to get fees. And the Wayfarer parties have responded in opposition to that and also asked for a stay. Okay, do I need to read that? Okay, it says this action and the SDNY action arise out of a dispute between actress Blake Lively on the one hand and Wayfarer, its co-founder Justin Baldoni, and others on the other hand. I had to make sure I unmuted myself. I don't want to pull an Omar, so. All right. In connection with the production of the film, it ends with this. In the first filed SDNY action, Wayfarer, Baldoni, and others asserted claims against the Times for defamation and false light in connection with an article and related video published by the Times in December 2024, which purported to detail a non-existent smear campaign allegedly waged by them against Lively in retaliation for her accusations of misconduct on the set of the film. And I've said this a million times before. I'll say it again, especially because now that things have settled down, people are picking apart old claims and kind of going over that. And this bot smear campaign thing is a super special fun narrative that's now being used everywhere on the internet by every celebrity who's ever gotten backlash. And if the smear campaign involves people getting upset over things that you actually did and said, I do not have sympathy for you. If somebody's like making up defamatory statements that are not in touch with the reality whatsoever and they're just rumors and gossip, fine. But if I see a video of you saying something that upsets people and your response is not to apologize or to double down, because if somebody doubles down, like if Blake Lively was like, yeah, I said that's a chassis flaw. Yeah, I said that, and that's what I meant. I wouldn't like it, but at least she's being honest, you know what I mean? But instead of apologizing or instead of, doubling down and holding your feet on the ground on that, you go and say, well, somebody's doing a smear campaign against me. My first question is not going to be, whose fault is it that I have now been made aware of your behavior? My question is going to be, did you actually do that? Did you actually say that? Is it true? So anyways, just wanted to point that out because that's kind of a fun thing that keeps coming up on Twitter and otherwise these days. Did this come out today? Yes, it did. Okay. All right. Smear campaign allegedly waged by them against Lively in retaliation for her accusations of misconduct on the set of the film. In June 2024, the federal court dismissed the claims against the Times on a motion to dismiss. Thereafter, in October 2025, the federal court issued an order effectively extending Wayfarer's time to appeal the dismissal of the claims against the Times to align the timing with a legally and factually overlapping related action, which remains pending. Okay. Notwithstanding, in September 2025, The Times prematurely commenced this action against Wayfarer seeking to recover, under New York's anti-SLAPP laws, its attorney's fees and costs incurred in defense of the Wayfarer's claim against the Times in the SDNY action. The Times acknowledges that its anti-SLAPP claim is entirely predicated on the federal court's dismissal of Wayfarer's claim in the SDNY action, which Wayfarer intends to appeal to the United States Court of Appeals for the Second Circuit. Accordingly, this action is premature and should be stayed to avoid significant duplication of efforts, waste of judicial resources, and likelihood of inconsistent rulings. Okay, give me 1 second. All right. They go into the background, which I might skim a little bit. We'll see, depending on how repetitive it is. On December 20th, Lively filed a complaint with the CCRD against Wayfarer and 10 other defendants, alleging she was sexually harassed during production of the film and subjected to a retaliatory smear campaign concurrently with the film's premiere in August 2024. Since no later than October 2024, Lively had been collaborating with the Times on a one-sided and defamatory hit piece on Baldoni and his colleagues. So, reminder, that was at least 2 months before the article actually came out. And they gave these people less than 24 hours, I think it was, to respond before they published. And a special friend of Taylor Swift's was involved in helping get that information from Stephanie Jones to Blake Lively. And of course, they, started setting things up with the New York Times long before the article came out. The New York Times obviously put a lot of care and attention into Lively's side of the story. And they kind of had a narrative that they wanted to go with before they really looked into the story at all, in my opinion, because they were talking to Blake Lively, Taylor Swift's bestie, and Taylor Swift, because we now know that she was involved in all of that, which as a former casual Taylor Swift fan, probably former, I don't know, not happy about that, but that's what it was. So they were collaborating no later than October 2024, based on what they can say here, but it was probably a lot earlier than that. It was probably shortly after the premiere, when things started to heat up from the public conversation, gossip around the movie. And to be honest, there was no need for this, because by the time this New York Times article came out, no one fucking cared what happened on the set of It Ends With Us. But Blake Lively was still reeling over, people's criticism of her own behavior and wanted blood. So that's what it was. Anyways. Since no later than October 2024, Lively had been collaborating with the Times on a one-sided and defamatory hit piece on Baldoni and his colleagues. On December 21, the day after the CRD complaint was filed, the Times published an article authored by Megan Twohey and others with the headline, "We Can Bury Anyone Inside a Hollywood Smear Machine." The article purports to detail an alleged campaign to tarnish Blake Lively after she accused Justin Baldoni of misconduct on the set of It Ends With Us. And again, I'll point out, the alleged campaign to tarnish Blake Lively talks about things that Blake Lively did and said on video, on record. This is pathetic. It doesn't get less pathetic. I've taken most of this month off from covering this case after spending a year following it very closely, and it still isn't any less pathetic. All right. On the same day, the Times published a video in which Twohey purported to explain the story from the Times' point of view. Right. On December 31st, 2024, Lively commenced an action in the federal court entitled Lively versus Wayfarer Studios against Wayfarer, Baldoni, Heath, Sarowitz, etc. Okay. The complaint asserted claims for, among others, sexual harassment and retaliation. On January 16th, 2025, the Wayfarer parties commenced a separate action in the federal court against Lively, her husband, Ryan Reynolds, her publicist, Leslie Sloan, and Sloan's company, Vision PR. On January 30th, the federal court consolidated two cases into a single action pursuant to FRCP 42A2 for purposes of convenience, expediency, and judicial economy, and finding that the two cases involve common questions of law and fact. Okay. 1 second. Somebody says Ryan was crying about the backlash towards his epically stupid marketing. Right. And one thing we know now, which we didn't know at the time the Wayfarer lawsuit was dismissed, was that Ryan and Colleen Hoover, the author of the book about this domestic violence relationship, who purports to be trying to put this story out there to support victims, is telling people who had criticisms of the film and the way it was marketed that they must be like 13 or 16-year-old children, and that they're stupid, basically, and that nobody actually hates Blake except for stupid child people. You know what I mean? Like, stupid children. So yeah, in retrospect, when we go back and look at everything, it's like even worse. Just the way they were like so absolutely refusing to accept criticism, that they like hated everyone who gave them the criticism, rather than thinking, okay, well, these people make up the public and the section of the public that we're targeting with this film, and we really need for this film to be successful. So rather than change the marketing that they were in charge of, they said it must be Justin Baldoni's fault, and everyone that's criticizing us is a dumb teenager. A dumb teenager, right? Yep. Okay. Does this mean the 400 million is back on? I mean, they haven't actually filed the appeal yet. They're just declaring their intention here. It's not like they're not declaring it in the Wayfarer Lively case. It's in the New York Times anti-SLAPP case in state court, but they're trying to get a stay because they don't want to pay the New York Times. They don't want to pay the New York Times fees or damages if they intend to appeal the dismissal of their lawsuit against the New York Times. So that's what we're looking at. Okay. 1 second, guys. Because I don't even know what would happen if they were awarded fees here, and then the federal judge overturns the decision, or not the federal judge, but the appeals court overturns the decision. That lawsuit gets reinstated, and then the New York Times loses the lawsuit over there. Like, then how would that even work? I don't know. So I'm not a lawyer, so remember, ask a lawyer. I'm just here for basically entertainment purposes and my own curiosity. So let's call it what it is. All right. Let's see. The Wayfarer parties opposed the motion. When the Times moved to dismiss the amended complaint, the Wayfarer parties opposed the motion. The federal court issued an opinion and order in which it dismissed the Wayfarer parties' defamation and false light claims against the Times without leave to amend. On September 12th, the Times moved for entry of final judgment in its favor against the Wayfarer parties. The Wayfarer parties did not oppose the motion. Okay. The federal court's extension of time to appeal from the dismissal order and judgment. Let's see. On October 17th, 2025, the federal court issued a memorandum and order directing the parties to show cause why final judgment should not be entered in the case, and why the Times motion should not be dismissed as moot, given that the federal court had already granted various defendants motions to dismiss, including the Times motion to dismiss, and the time for the Wayfarer parties to file a further amended pleading had expired. The Wayfarer parties had no objection to the proposed relief and thus did not respond to the memorandum and order. The Times also did not respond to the memorandum and order. Okay. By letter dated October 24th, 2025, Lively requested that the federal court hold in abeyance the Wayfarer parties' time to file an appeal from the dismissal order pending the entry of an order resolving her motion for fees. In a memorandum and order dated October 31st, the federal court explained, the FRCP permit district courts to treat motions for attorney's fees as Rule 59 motions for purposes of the Federal Rules of Appellate Procedure, and the Federal Rules of Appellate Procedure explain that where a Rule 59 motion has been filed prior to a notice of appeal, the time to appeal begins when the district court rules on that motion, not when it enters the judgment. So that's why Brian Friedman was so mad at Harvey Levin when he went on TMZ's podcast. What's it called? Two Angry Men. I don't watch that shit because TMZ is vile and disgusting. But that's why Brian Friedman was so upset when he went on their podcast. He was like, you know this. Like, Harvey Levin knows this as an attorney, and he still allowed his publication to put out false information for clicks. Because that's what all the other headlines in the legacy media were reporting. Because, let's be honest, the legacy media doesn't know any more than I do. But Harvey Levin does. So TMZ could do better not just in this case, but in many others that are going on right now. And they choose not to. So that's why he was so upset about that. Give me 1 sec. All right. The federal court further noted that, to increase judicial efficiency, a district court is therefore permitted but not required to delay the finality of the judgment for appellate purposes under revised Federal Rule of Appellate Procedures 4A until the fee dispute is decided. The federal court held that such approach was warranted, determined that Lively's pending motions for attorney's fees qualify as motions for attorney's fees under FRCP 58, and that judicial efficiency would be best served by simultaneously handling any appeals related to the request for fees with any appeals from the underlying judgment, given the significant substantive overlap between the two. Okay. Notably and particularly relevant to Wayfarer's motion to stay this action, the federal court held that any prejudice to the times caused by delaying the time to appeal is insufficient to overcome considerations of judicial efficiency and the prevention of piecemeal appeals. Simply put, the prejudice the Times has identified, if any, is minimal, while the benefit to judicial efficiency in handling appeals simultaneously would be substantial. Accordingly, the federal court ordered that final judgment be entered in the case pursuant to FRCP 58E, granted Lively's motion to treat her pending motions for fees as motions under whatever the fuck that means. I'm sorry, guys. I don't know. When it comes to FRCP 58 and 59, I don't know. But granted Lively's motion to treat her pending motions for fees as motions under FRCP 59 for purposes of Federal Rule of Appellate Procedure 4A4, and C, denied the Times motion seeking entry of partial judgment as moot. Okay. On October 31st, 2025, the federal court entered a judgment in case number, and that's the Wayfarer case against Lively. Okay. The Wayfarer parties intend to appeal the dismissal order and the judgment. Okay. You just know the MSM aren't going to report this. That's why I love you reading to us. Oh, well, thank you. But they may or they may not, because things have slowed down here and they want the clicks. You know what I mean? So like they'll probably pick a sentence or two out of here and pop it out there and be on the side of the New York Times. But yeah. Shannon Nicole, thank you for the $5. Happy Aloha Friday, Lauren. Oh, thank you very much. Appreciate that. All right. The Wayfarer parties intend to appeal the dismissal order and the judgment. The grounds for appeal include, but are not limited to, the federal court's erroneous A, determination that the Wayfarer parties failed to allege the Times statement in the article that they engaged in a smear campaign was made with actual malice, and B, presumption on Rule 12b6 motion that the Wayfarer parties had spread negative content about Lively based upon self-serving and cherry-picked evidence provided by Lively to the Times instead of accepting the Wayfarer parties' well-pleaded allegations as true. The Wayfarer party's time to appeal the dismissal order and the judgment has not expired because Lively's motion for fees have not been decided by the federal court. Okay. The Wayfarer party's motions for judgment on the pleadings and for summary judgment, each of which seeks dismissal of Lively's claims against them, are sub judice, as they haven't been ruled upon. The trial of Lively's claims, if any, remain after these dispositive motions are decided, is scheduled to commence on May 18th. Is it May 18th? Yeah, it is. Okay. If they hadn't moved that trial to May, it would have been coming up like right now in a couple weeks. So I'm really glad they did. Not only because we have no idea what's going to go on with these motions, but also because it would have been fucking cold. It would have been fucking cold for me to be standing out there in New York for I don't know how long during a trial in March. So I wasn't ready for that. Yeah. Hey, Meg, what's up? Parker Posey, thank you for the $2. Okay, Justin, go Beast Mode XL. All right, give me 1 second here, guys. Okay. Right. Meanwhile, on September 30th, the Times commenced this action against Wayfarer seeking to recover pursuant to New York's anti-SLAPP laws. its costs, fees, and expenses incurred in the defense of the Wayfarer party's claims in the SDNY action. Okay. Let me make sure I didn't skip anything there. I think good. Give me 1 second here. Okay. All right. So they asked for a fee recovery pursuant to a New York's anti-SLAPP, right? Specifically, the Times alleges that the Wayfarer party's claims against the Times in the SDNY action constituted an action involving public petition and participation as contemplated by the anti-SLAPP law, and that the dismissal order makes clear that Wayfarer and its affiliates both commenced and continued the lawsuit against the Times without a substantial basis in fact and law, which is obviously contested. I mean, I've read their response to this, which it was a while ago. It's been a few months since they, answered these complaints, the anti-SLAPP complaint, but you can always go back and find it. Let's see. Thereby entitling the Times to recovery of its costs and attorney's fees. On December 2nd, Wayfarer filed its answer. Yeah, so it was a couple months. Yep. Which denies the substantive allegations and includes various affirmative defenses. On January 14th, 2026, the Times moved for summary judgment on its sole claim for violation of civil rights law sections 70A and 76A. In the motion, the Times argues that the federal court's dismissal of the Wayfarer party's claims against the Times for failure to state a claim proves that the Wayfarer party's lawsuit against the Times was commenced or continued without a substantial basis in fact and law. Okay. Then they talk about the legal standard here. Honestly, I'm going to skim over a lot of this. You guys know this is not my area. This is something I'll talk about with Omar, because he's usually one I go to with this stuff. CBLR 2201 states that except where otherwise prescribed by law, the court in which an action is pending may grant a stay of proceedings in a proper case upon such terms as may be just. The determination as to whether to grant a stay rests within the court's discretion. Okay. Although there is some authority that a stay is justified only when there is complete identity of the parties, the causes of action, and the judgment sought, there is substantial authority holding that a stay is a provident. Is it provident or provident? I don't know. Exercise of discretion, even absent complete identity of the parties and issues, where there are overlapping issues and common questions of law and fact, and the determination of prior action may dispose or limit issues which are involved in the subsequent action. Okay. I'm going to skim down here. In general, the duplication of effort, waste of judicial resources, and possibility of inconsistent rulings in the absence of a stay outweigh any prejudice to the party opposing the stay. Okay. Courts also consider the sequence in which the actions were commenced and usually defer to the first filed case. Right. These discretionary factors weigh in favor of granting a stay. The Times and Wayfarer are both. Hold on. Nope. I'm getting ahead of myself. Okay, let me start over. The Times and Wayfarer are parties in both the SDNY action and in this action. There we go. Nailed it. Sorry. Give me 1 sec. Okay. Justin got New York TUI timed IMO. I've never heard anyone say that. Okay. All right. These discretionary factors weigh in favor of granting a stay. The Times and Wayfarer are both parties in the SDNY action, and in this action, there is no dispute that there are overlapping issues and common questions of law and or fact. The Times complaint and its summary judgment motion both contend that the Times is entitled to a judgment under New York's anti-SLAPP law because the federal court issued the dismissal order dismissing Wayfarer's claims against the Times. The Times argues that the federal court's dismissal of Wayfarer's claims establishes in and of itself that Wayfarer's lawsuit against the Times was commenced or continued without a substantial basis in fact and law in violation of New York's anti-SLAPP law. However, if Wayfarer is successful on its appeal from the dismissal order and its claims against the Times are reinstated in the SDNY action, the Times will no longer have any basis to allege as it does, that Wayfarer's claims against the Times and the SDNY action lacked a substantial basis in fact and law. Without a stay, there is risk of inconsistent rulings. This court may determine that Wayfarer's claims were commenced or continued without a substantial basis in fact and law, while, to the contrary, the Second Circuit decides that Wayfarer properly stated claims against the Times and the SDNY action for defamation and or false light, and reverses the dismissal. So that is kind of the question I had just a few minutes ago, which was, what happens if this court rules in favor of the Times here, but then the appeals court says, that Wayfarer did properly state their claims against the Times, and that gets reversed. Judicial and party resources will be wasted without a stay because this court will have to determine the Times summary judgment motion, hear oral argument, schedule conferences, potentially oversee discovery, etc., none of which will be necessary if Wayfarer's claims against the Times and the SDNY action are reinstated. I mean, it does make sense to give them a stay. And I remember when it came to discovery, the New York Times was actually given a stay in the Wayfarer action in federal court because they had a pending motion to dismiss. So I don't know. I don't know the standard for granting that thing versus denying it, but I know that the New York Times was granted a stay in their motion to dismiss so that they didn't have to participate in discovery actions. So Wayfarer saying, we don't want to do all this if the appeals court is going to reverse our denial. Okay. I'm going to skim through this. The SDNY action was filed 9 months before this action. Wayfarer and the Times have engaged in substantial motion practice in the SDNY action with respect to Wayfarer's claims against the Times, and the parties will continue to expend significant resources in the SDNY action by virtue of Wayfarer's forthcoming appeal from the dismissal order. Neither the Times nor Wayfarer will be prejudiced by a stay of this action, particularly because if Wayfarer is successful in having its claims against the Times reinstated, there is no claim for the Times to pursue, because its claim is predicated on the dismissal order. So everything they're asking for here in the anti-SLAPP suit is based on that dismissal order. If the dismissal gets overturned, then there's no point in even doing this. Okay. Moreover, the Times could not complain that Wayfarer's time to appeal from the dismissal order has been unjustifiably extended by the federal court because the Times failed to respond to the federal court's order to show cause. On the other hand, if a stay is not imposed and if the Times is granted summary judgment herein, Wayfarer will be prejudiced by having to satisfy the judgment and potentially appealing such judgment to the appellate division while pursuing its appeal to the Second Circuit from the very order in another case, the dismissal order, that served as a basis for that judgment. For the reasons set forth and in the accompanying papers, the court should stay this action pending the final resolution of the SDNY action, including a stay of any interim deadline to substantively oppose the Times summary judgment motion. Okay. And then there is an affirmation here by Kevin Fritz that we'll go over really quick. Give me 1 second. Someone says, is this just the NYTs or is he appealing Ryan as well? They're one and the same. So if they're appealing the decision on like that whole dismissal, that's going to be against Sloan, Reynolds, the New York Times, and Vision PR. So, okay. Kevin Fritz, I got to meet briefly at the courthouse last month. Kevin Fritz is cool. I like his writing. I have had that one interaction with him. We have not had any contact that would warrant a subpoena. Please do not send me another subpoena. These are my own opinions, not the opinions of Kevin Fritz. Hey, Meg, thanks for the $20 super sticker. I appreciate you. Meg is helping me out a lot with my subreddit stuff. I don't know how to do Reddit as a mod, so okay. Let's see. Like I said, this is from Kevin Fritz. I'm going to skim down here to the background. This action and the SDNY action arise out of a dispute between actress Blake Lively on the one hand and Wayfarer, its co-founder Justin Baldoni, and others on the other hand. Looks like this is a lot of what they said in the other documents. So I'm not going to read all that. Lively filed with the CCRD. Okay, Exhibit 1 was the CRD filings. I didn't pull up the exhibits because they're all stuff we've seen before. Okay. The next morning after the CCRD complaint was filed, on December 21st, the Times published an article authored by Megan Twohey. So, right, the Times and Lively were conspiring on this article as late as October 2024, 2 months before this article came out. So probably before that. And then they give Wayfarer notice that they're going to publish this article and notice to respond within 24 hours of the publication of that article, late at night on the weekend before Christmas, a few days before Christmas. So that was a fucking mess. Terrible journalistic practice, if you ask me. If you're going to do something as serious as a sexual harassment lawsuit between celebrities and try to market as a Me Too movement related action, you better do a better job than that. And Megan Twohey failed to do that, which unfortunately kind of tarnishes her other work with the Me Too movement, in my opinion. But, you know, we have Megan Twohey's work on the Me Too movement in the past, and now we have Megan Twohey doing work on the Me Too movement because some director called the actress's outfit sexy when she asked that her character appear sexy. Okay. All right. Give me 1 sec. Okay. They included copies of the CRD and all that. It says the article purports to detail an alleged campaign to tarnish Blake Lively after she accused Dutch and Baldoni of misconduct. We know all that. The article claims that Lively's CRD complaint includes excerpts and thousands of pages of text messages and emails that she obtained through a subpoena. These other documents were reviewed by the New York Times. I don't think we need to talk about that subpoena right now, but messy. On the same day, the Times published a video in which Twohey purported to explain the story. Okay. On December 31st, Lively commenced an action in the federal courts. We know about that. The complaint asserts claims for sexual harassment, retaliation, breach of contract, and intentional and negligent infliction of emotional distress. She, of course, dropped her emotional distress claims later on. My speculation on that is that she did not have the documentation to back up intentional infliction of emotional distress claims or negligent infliction of emotional distress claims. She was going to go with garden variety emotional distress, in which case she would ask her friends who appeared to function as additional high school bullies on the set of that movie to back up her claims of emotional distress, which was basically just bitching in text messages. So good luck. I don't know. All right. On January 16th, the Wayfarer parties commenced a separate action in the federal court against Lively, her husband, her publicist, blah, blah, blah. We kind of read this already. The complaint asserts claims for civil extortion, defamation, false light invasion of privacy, breach of the implied covenant of good faith and fair dealing, intentional interference with contractual relations, intentional interference with prospective economic advantage, and negligent interference with prospective economic advantage. Okay. The court consolidated the cases, which we know. Times moved to dismiss. On June 9th, the federal court issued an opinion and order dismissing the parties' claims against the Times without leave to amend. Okay. So like I said earlier, they couldn't amend that. Their only recourse here was to appeal. Right. On September 12th, the Times moved for entry of final judgment. The Wayfarer parties did not oppose the motion. Okay. On October 17th, the federal court issued a memorandum and order directing the parties to show cause why final judgment should not be entered and why the Times motion should not be dismissed as moot, given that the federal court had already granted various defendants' motion to dismiss. And the time for the Wayfarer parties to file a further amended pleading had expired. A true copy of those orders is included in the exhibits. The Wayfarer parties had no objection to the proposed relief and thus did not respond to the memorandum and order. The Times also did not respond to the memorandum and order. Right. Okay. By letter dated October 24th, Lively responded to the memorandum and order by requesting that the federal court enter final judgment. while also treating her pending motions for attorney's fees as timely motions under FRCP 59. Lively contended that judicial economy favors a single appeal rather than two or more, as could result if the merits appeal proceeds ahead of appeals from the court's determination of the pending motions and any further fee motion that may be filed. Stated differently, Lively requested the federal court hold in abeyance the Wayfarer party's time to file an appeal from the dismissal order pending the entry of an order resolving her motions for fees. So the timer for their appeal doesn't start until the fees are ruled upon, right? Okay, in a memorandum in order dated October 31st, the federal court explained, and we already read this, so I'm not going to mess with that too much. A lot of this is just restated from the motion we just read. The FRCP permit district courts to treat motions for attorney's fees as Rule 59 motions. Okay. The time to appeal begins when the district court rules on that motion, not when it enters judgment. Got it. The federal court further noted to increase judicial efficiency, district court is therefore permitted but not required to delay the finality of the judgment for appellate purposes. Okay. The federal court held that such approach was warranted, determined that Lively's motion for fees qualify as motions for attorney's fees under FRCP 58, and that judicial efficiency would be best served by simultaneously handling any appeals related to the request for fees with any appeals from the underlying judgment, given the significant substantive overlap between the two. Notably and particularly relevant to Wayfarer's motion to stay this action, the federal court held that any prejudice to the times caused by delaying the time to appeal is insufficient to overcome considerations of judicial efficiency and the prevention of piecemeal appeals. Simply put, the prejudice the Times has identified, if any, is minimal, while the benefit to judicial efficiency in handling appeals simultaneously would be substantial. Okay. The federal court ordered that final judgment be entered in the Wayfarer case pursuant to FRCP 58. They granted Lively's motion to treat her pending fee motions as motions under FRCP 59 for purposes of appellate procedure, and they denied the Times motion seeking entry of partial judgment as moot. Okay, one second here. On October 31st, the federal court entered a judgment in the Wayfarer case. They included that in exhibits. The Wayfarer parties intend to appeal the dismissal order and the judgment. The grounds for appeal include what we just read pretty much, which is the court's erroneous determination that they failed to allege that the Times made their statement about the smear campaign with actual malice, and B, the presumption that on a Rule 12b6 motion, the motion to dismiss, that the Wayfarer parties had spread negative content about Lively based upon self-serving and cherry-picked evidence provided by Lively to the Times, instead of accepting the Wayfarer parties' well-pleaded allegations as true. Okay. The Wayfarer parties' time to appeal the dismissal order and the judgment has not expired because Lively's motions for fees have not been decided by the federal court. The Wayfarer parties' motions for judgment on the pleadings and summary judgment, they're pending a ruling on that. I don't think we need to do that. Otherwise, the trial will happen on May 18th. Again, a lot of this is repetitive from what we just read. Let's see. Meanwhile, on September 30th, the Times commenced its action against Wayfarer here in the state courts for costs and fees under anti-SLAPP laws. Specifically, the Times alleges that Wayfarer's claims constituted an action involving public petition and participation as contemplated by the anti-SLAPP law, and that the dismissal makes clear the Wayfarer parties and their affiliates both commenced and continued the lawsuit against the Times without substantial basis in fact and law. Okay. Let's see. Times moved for summary judgment on January 14th, and in the motion, the Times argues that federal court's dismissal of Wayfarer's claims against the Times proves that the Wayfarer party's lawsuit against the Times was commenced or continued without a substantial basis in fact and law. All right, got it. Like I said, a lot of that was repetitive, so I didn't want to go over the rest word for word, but okay. All right, guys. That's all I got for now. Like I said, this was filed in the state court in the anti-SLAPP lawsuit filed by the New York Times against Wayfarer Studios. I have to get back to work now, though. So if anything else comes up I'll always read that, but I'm not expecting the judgment from Lyman to come down yet for a little bit longer. I think we kind of, you can only really speculate, but I kind of feel like his ruling will not happen tomorrow. Let's put it that way. So whenever that comes up, I'll read that. Like I said, tomorrow night I may go over the New York Times follow-up article on this case, the lively action, which is a shit show, and we'll go from there. Whatever else comes up. All right, that's all I got for now, and thanks for joining. I will see you guys soon. Actually, let me see if there's someone I can redirect to. I don't know if anybody else is doing any coverage right now. Let's see. We got Ricardo. We got. Yeah, I'm gonna send you guys over to Prof. Joe. She's doing the Richens trial. Please tell her I said hello. And if you guys haven't seen her video from last week, I was on her show to talk about this case, which is fun, and she's really awesome. She's fun to listen to, and she's a smart lady. So if you want to, please, when I end here, it'll redirect you. I'll also post a link to that right here in the chat before I leave. Okay. But we had a good time talking about this last week. So right, here we go. I'm posting the link in the chat right now, and then this will also redirect you guys if you don't see it. Don't forget to hit the like button on the stream for me if you can. That would help me out a lot. There we go. I'll pin that. And like I said, please tell my friend Joe that I said hi. And I will see you guys tomorrow. I'll see you tomorrow. How about that? Bye.